U.S. Supreme Court conferencing with the gun ban challenge out of Cook County, while you've also got immigration enforcement pushback. Plus, we've got to tackle a bill that's on the governor's desk about end-of-life options. It is Illinois in Focus Daily on this Friday. I'm Greg Bishop, editor of the Center Square at Illinois. So go to the Illinois page. You can see the stories that myself and the team put together to keep you informed of what's going on in the land of Lincoln. Obviously, you can get the headlines in your inbox each and every weekday morning. You can join us here in the live cast, and you can find clips of this program and also of other things going on in Washington, D.C. and across the country with the Center Square. So greatly appreciate you guys being here this morning. One thing I wanted to start with is an announcement from U.S. Steel. They are restarting their Granite City blast furnace to support customer demand. This coming out yesterday, driven by consumer data and demand as part of the company's ordinary course of business planning, U.S. Steel has begun the process to restart the operation of one of two blast furnaces at Granite City Works. After several months of carefully analyzing customer demand, we made the decision to restart the blast furnace. The president and CEO of U.S. Steel said, it went on to say that steel remains a highly competitive and highly cyclical industry, but we're confident in our ability to safely and profitably operate the mill to meet 2026 demand. We look forward to partnering with all stakeholders, including the United States steel workers and elected officials, to ensure a safe and efficient startup, to discuss support for Granite City Works. So what that means, the governor, he put out a statement yesterday evening as people were closing up for the day, and here's what he had to say. He said, today's announcement from U.S. Steel is welcome news for the residents of the proud steel workers of Granite City. Driven by consumer demand, the decision will result in new, good-paying jobs and significant investment in the facility. So the governor goes on to thank those who helped make this happen to get that sites back opened up. So just wanted to get that out there this morning. Not going to spend an entire segment on it, but something for people to know, especially down in Granite City in the Metro East area with those jobs coming back for Granite City Steel. All right, so plenty to tackle. We'll get to the U.S. Supreme Court conferencing with the ban of certain types of firearms out of Cook County, the Viramontes case. They have a conference today. We'll discuss that, but also the status of other litigation against the gun ban and where those are at right now. So stay tuned for that. We'll also talk a bit about the Illinois Secretary of State's office, an announcement they made yesterday, but also follow up to a response I got from them about enforcement of commercial driver's licenses and English language proficiency. So we'll share that with you. But we'll also hear some of what Governor J.B. Pritzker had to say about a bill that's on his desk concerning the measure that passed early Halloween morning, allowing for physician-assisted suicide or end-of-life options, as supporters call it. So stay tuned. All of that's coming up here with Illinois in Focus each and every weekday morning here with you on this Friday. Happy Friday, everyone. U.S. Supreme Court has a conference today, and we could find out if they're going to take an Illinois case banning firearms on Monday. So we'll definitely be clicking refresh whenever they do that order list at about 8:30 our time on Monday. But today they're going into conference, and one case that they could be dealing with is a challenge to a ban out of Cook County that ultimately wrapped in the Illinois ban. So let's get to that and also look at some of the status of firearms litigation across the state. It is Illinois in Focus Daily. I'm Greg Bishop. Wake up with us each and every weekday morning for more here with the Center Square. Go to thecentersquare.com and get the latest headlines in your inbox. So if you go to the U.S. Supreme Court's website, you will see that they've got their calendar. And the calendar, it shows today green. What is green? It's conference days. And what does that mean? They're going to get together and they're going to discuss whether or not they take certain cases. So today being the 5th, you've got a conference day. But Monday, the 8th, you've got argument days set. So you also have order list issuance, and I think on the 8th, as you can see here, we clicked on the 8th, they are going to release an order list at 9:30 their time, that's 8:30 our time, on Monday. And what exactly could they be showing us? Well, we could be seeing the Veramontes case, which has cleared the appeals court after clearing the district court and is now ripe for the U.S. Supreme Court. And back in August, after the 7th Circuit Court of Appeals sided with Cook County on upholding their prohibition of owning certain types of firearms, the plaintiffs in this case, the Veramontes case, they decided to take it to the U.S. Supreme Court. So they filed a writ, and the court then eventually distributed it to conference last month. So again, that conference happening today. So this is the Veramontes case. And we've discussed here a bit about some of the lower court's rationale, essentially indicating that it's not a great record. And that could mean this is pure speculation. I am not an attorney. I am merely a reporter who's watching this and has been watching this and the trajectory of all of these cases over the past, 2-3 years now, as Illinois had a ban put in place January of 2023, and all the conversation before that in various, municipalities and jurisdictions that were having their own bans, like Deerfield, Naperville being another one. We'll talk about the Beavis case here in a moment. But then, obviously the state enacting the gun ban in January 2023, bringing all kinds of litigation. So the U.S. Supreme Court looking at the Veramontes case, which started before Illinois banned firearms. It was a Cook County-centric case. The lower courts heard that. The appeals court heard it, and then it went off to the U.S. Supreme Court. So that's what we're going to see possibly Monday, what the U.S. Supreme Court does. But I wouldn't be surprised if the U.S. Supreme Court says this case isn't ready, and that they point to another case, the Barnett case, that's pending in the 7th Circuit U.S. Court of Appeals. And people have been asking throughout the week, hey, any updates on the Second Amendment? Well, you've got this case that's still in the 7th Circuit Court of Appeals after being heard September 22nd. That's the Barnett case, the case where the district judge sided with the plaintiffs, saying that the law was unconstitutional. Now, what's different between the Barnett case, which has Harrell in it and the State Rifle Association and a variety of other groups, 4 different plaintiffs groups all together in this case from the Southern District, where they had a 4-day bench trial in 2024, and the judge there said that the law was unconstitutional, and then goes to the appeals court. Appeals court sat on it for months. The plaintiffs were like, hey, we need some certainty here because we have a judge saying it's unconstitutional, but you guys aren't doing anything about it, and we're sitting here in limbo. And then the appeals court says, okay, we're going to hear it. The appeals court hears it, and that's where we're at right now with the Barnett case. But it's got a strong record, and some of the court filings throughout all of this in all different cases indicates that seems that they're all waiting for the Barnett case, including the Beavis case, because the Beavis case has a filing back in July that we talked about, where essentially they said that they're going to withhold hearings, and the case shall remain stayed in the district court pending what happens in the Barnett case with the appeals court. And you've got a hearing that's a joint status report that's required in the Beavis case the 15th of this month. So 10 days from now, there will be a status report in the district court of the Beavis case. Now, the Beavis case also coming before Illinois banned firearms statewide. The Beavis case coming out of Naperville with law weapons owner Robert Beavis suing the city of Naperville back in November of 2023, I believe. District court preliminary grounds, there are certain actions that are taken, and then it goes to the appeals court on those preliminary grounds, went all the way up to the U.S. Supreme Court on preliminary grounds, now it's kicked all the way back to the district court. Beavis eventually wrapping in the challenge to the Illinois law into his case as well, so it's both state and a local challenge that Beavis brought. So we're still waiting on I guess the Barnett case to ultimately come to full fruition out of the appeals court and then go off to the U.S. Supreme Court. How quick is that going to happen? Again, once you're in the appeals court, you've got a 3-judge panel. And that 3-judge panel is what heard the case Barnett v. Raoul back in September. Now, could they, whoever is the one that's defeated in the appeals courts, request an en banc panel of the appeals court? So the entire appeals court, not just the 3-judge panel, but the entire appeals court? It's possible. Will the plaintiffs do that if they lose? They have the option to request that en banc panel, but they also have the option to go right to the U.S. Supreme Court. So is that the trajectory we're on? Or does the appeals court, the 7th Circuit Court of Appeals, 3-judge panel, side with the plaintiffs on this, and the state has to make that decision? Do we go en banc, which would take more time? Honestly, it would, even if the 3-judge panel makes a ruling and it goes against the states and they uphold the district judge saying it's unconstitutional, you have the state having the option of going en banc. How much more time that would add on to getting this completely dealt with by the U.S. Supreme Court, still uncertain. So a lot of things pending here when it comes to the gun ban challenge. But today, you do have the U.S. Supreme Court going into conference to deal with the Viramontes case. Again, a case that started before Illinois banned firearms. It was challenging the Cook County ban. And that case has been all down the court system. It's out of the appeals court. It's in the U.S. Supreme Court's hands. They will decide, could we find out Monday, if they're going to take that case. So that's where we're at in all of this. And we'll do what we can to keep you updated here with Illinois in Focus Daily, all right? So like, subscribe, hit that notification bell, and wake up with us each and every weekday morning as we break things down for you and get the headlines in your inbox. Go to thecentersquare.com and sign up for the newsletter today. Plaintiffs group that brought suit against the U.S. Department of Homeland Security because of their use of force in enforcing immigration law have decided to withdraw their challenge after the federal government went to the appeals courts and had a lower court's action reversed. Good morning. It is Illinois in Focus Daily. I'm Greg Bishop, and a lot of litigation between the federal government and the state of Illinois when it comes to the issue of immigration enforcement. And the most recent is a hearing yesterday in District Court, Northern District of Illinois, where plaintiffs groups, including members of the media and immigration activists, were essentially asking a judge to dismiss the case that they brought against the U.S. Department of Homeland Security over use of force. And this has generated a lot of interest, a lot of activity, but ultimately what came out of that hearing yesterday was the judge having another hearing set for January when they're going to come back and ultimately have a decision here soon after to decide whether to dismiss this case. So let's go to some of the the latest here in the courts, because the immigration debate, also including the Secretary of State's office here in Illinois, critical of ICE and rental car companies when it comes to license plates. But we've also got immigration enforcement when it comes to CDLs being questioned, with state U.S. Congresswoman saying that she's willing to withhold federal funds from states like Illinois that may be flouting federal law when it comes to immigration enforcement and CDLs. So let's get to all of this, all right? And I'll try to my hardest to keep this as concise as possible, because there's a lot here. So you have the plaintiffs in their case about excessive use of force, essentially saying that they want to have this case dismissed. And what that means is you have a hearing that happened yesterday where Judge Sarah Ellis heard from the plaintiffs saying they wanted it dismissed, and the federal government in the back and forth, essentially the federal government saying, what kinds of things are going to be unsealed in this, and how are we going to proceed forward in this case, because the federal government appealed to the U.S. Supreme Court, or rather to the appeals court. Let me correct that. So last month, federal Judge Ellis sided with the plaintiffs, issuing a temporary restraining order against the federal government from using excessive force. And then you had the appeals court, at the federal government's insistence, reverse that lower court's order of the temporary restraining order against the use of force. So the federal government's got a preliminary victory out of the appeals court. And that's an indication of what ultimately the appeals court may do about the lower court's ultimate decision. So apparently the plaintiffs group said, we're just going to dismiss this case. So all the generated activity, the media activity, and the videos that came out, and the deposition of Gregory Bavino, a DHS official, all of that out, and the questions and the consternation and the debate about use of force, especially when it comes to the issue of how DHS can protect themselves from protesters who become violent. And that's something that also wraps in the conversation about the use of the National Guard, which we're still waiting on the courts to ultimately deal with. So all of this while you've got the courts also having to deal with the question of Illinois' migrant sanctuary policies that the Trump administration has sued Illinois over, saying they're unconstitutional. We'll see how that case plays out as well. So still a lot more to be done about what happens with the case here, challenging excessive use of force, because that hearing is now set for January 8th, where a judge will ultimately have more to say about the injunction they issued last month that was reversed by the Seventh Circuit Court of Appeals. But the plaintiffs group here, Chicago Headline Club, they put out a statement after the hearing yesterday, and here's what they had to say. They said, the Chicago Headline Club went to federal court to stand up for freedom of the press when federal agents tried to trample upon our constitutional rights. It's that simple, they said. Our organization backs reporters as they pursue fair, impartial, honest, and truthful journalism without fear or favor. Our court case accomplished what we wanted, a ruling that prevented federal agents from interfering with our right to cover the news. Reporters, protesters, and religious leaders faced tear gas, pepper balls, and other over-the-top actions perpetrated by federal agents during Operation Midway Blitz. We respectfully note the U.S. District Court Judge Ellis reviewed video and evidence and found the government's version of what happened during Operation Midway Blitz was flat out not credible. She said the federal government's aggressive activity shocks the conscience. As we noted earlier, the Headline Club wrote, Commander Bavino left town quickly once Ellis exposed the truth about Operation Midway Blitz actions and lies told by the federal agents. We expected an appeal and we moved to dismiss the suit. We'll take the win, and we're prepared to go back to court if federal agents once again threaten our sacred First Amendment rights. Today, the federal government argued in courts that we can't dismiss the suit and then file new action later if the government comes back and causes more harm in the future. As Judge Ellis noted, the view is contrary to the law. The federal government harms journalists in Chicago in the future. We and our attorneys will fight for our rights. So, again, you can see here the statement from the Chicago Headline Club that essentially saying, hey, we're going to sue again if we want, even though they had the appeals court reverse the order that they got in the district courts and the federal government saying they want to, continue with the case. So what happens with the hearing next week in this particular use of force case will be interesting next month, rather, whenever they have that hearing to ultimately determine if this case is going to be dismissed, first of all, and if the case is going to be dismissed with prejudice, meaning they can't bring the case again. So it might be dismissed without prejudice, meaning they can bring the case again and have all of this come back up. But obviously, when it comes to covering in news and First Amendment, being able to be there as a neutral observer, that's one thing. But when it crosses the line into getting into interfering with law enforcement activities, that's going to be an interesting question that I imagine this case might develop over time. So a lot more to watch on that here with Illinois in focus. Moving on, though, with the other immigration issues, Illinois Secretary of State Alexis Giannoulias says he's cracking down on rental car companies for permitting ICE in their swapping and altering of license plates. Here is what Secretary of State Alexis Giannoulias had to say in a video message that he shared on social media yesterday.
Has received hundreds of public complaints about federal immigration agents using rental cars with swapped or altered license plates during large-scale deportation operations right here in Illinois. Let me be very clear. Swapping Illinois license plates is illegal, period. and no one, including federal agents, is above the law. That's why we sent formal notices to national rental car companies reminding them that if their vehicles are used this way, they will and can be held liable. When our investigation confirmed that ICE agents switched plates on a rented vehicle, we revoked that license plate immediately. We also issued a cease and desist letter to the Department of Homeland Security. The message is simple. If a vehicle is registered in Illinois, it must follow Illinois law, regardless of whether you are Homeland Security or a rental car company. This is about public safety, transparency, and accountability. So if you see vehicles with missing, masked, or mismatched plates, report it to our new Plate Watch hotline. Together, we're making it very clear. When it comes to protecting our communities, no one is above the law.
So again, that's the Secretary of State there laying out what he says is a big problem with federal agents masking license plates. And here's some of the letter that he shared yesterday that he says he sent back in October about swapping license plates on Illinois registration. And it goes on to say that there have been multiple reports of federal ICE agents swapping out license plates displayed on vehicles that are registered in the state of Illinois. And essentially just heard what the secretary had to say there. So clearly, he also sent a letter to 19 rental car companies, and we'll hear more about that, I imagine, as that story develops. But Secretary of State was also, part of our story yesterday concerning the CDL enforcement issue. And Congresswoman Mary Miller, we chatted with yesterday about that, says she's willing to withhold federal dollars over that CDL issue. So data that we got here at the Center Square from Illinois State Police showed nearly 1 in 5 CDL holders with English language proficiency infractions have licenses issued by the state of Illinois. Miller said that that's wild, and she also had her own sampling that she had done.
If you don't stop the funding to the states that are flouting our laws, they're not going to change. I have a bill, the Safe Driving Law Act, that will rescind half of the highway funding to states like Illinois that refuse to cooperate. Our highways are not safe. And I completely do not believe that number, 1 in 5. I have, in plain clothes, gone from truck stop to truck stop in my district, and I go to the cashier and I ask them this question: how many of the truckers come in here speak no English? And every single time they've told me almost all of them. And it's just outrageous. And the other thing, we have allowed illegals and foreigners to take these jobs from the American people. These used to be good jobs for people that didn't go to college. And we should restore the trucking industry back to the American people. And I want to go after the trucking companies is another thing that's hiring these people. And Illinois is quite a trucking hub. We've got so many freight rails that come into Chicago. And it's a trucking hub, Illinois is, and in the center of the nation. We definitely need to deal with this. It is a threat to the American people on the highways.
So I asked the Illinois Secretary of State's office for some information and what they would do about possible federal funds being withheld if Congresswoman Miller gets her bill across the finish line. They didn't necessarily respond to the issue of what would happen if Illinois lost those highway dollars, but the Illinois Secretary of State's office did say that the office takes the federal standards for commercial driver's licenses seriously, quote, because they are critical to road safety. A statement provided to me by the spokesperson for the Secretary of State's office says that we will continue enforcing federal requirements and working with our partners to ensure CDL holders in Illinois meet all licensing and safety obligations. The agency said CDL applications are not allowed to use a translator at any point in the licensing process, and it takes about 45 minutes for a test and requires continuous communication between the applicant and the examiner. And the spokesperson went on to say, if an applicant cannot understand or respond to questions asked by our staff, whether during testing or even at the counter when providing basic information, the process is stopped and they are not issued a CDL, according to the spokesman from the Secretary of State's office. The Secretary of State's office giving me that statement, but yesterday when we talked with Congresswoman Mary Miller earlier, she answered the question of has she talked to the Secretary of State's office?
Well, they won't talk to me. They're completely uncooperative. And finally, I do not believe a thing that they say. They lie without shame. And, I think the facts speak for themselves. I've had multiple accidents in my own district of illegals that have driver's licenses and CDL licenses. And I've talked to victims' families. Not one Democrat has reached out to their family.
So Miller critical of the Secretary of State's office and also critical of Democrats. But if you look at the Secretary of State's office website when it comes to the CDL issue, and you can read up on how you can get a CDL, the website shows that only U.S. citizens and lawful permanent residents can apply for a CDL. But the Deferred Action for Childhood Arrivals can be considered in that CDL application process. The federal DACA program, it was frozen earlier this year pending legal action. The U.S. Citizenship and Immigration Services Agency says that it will accept initial DACA requests, but they're not processing them at this time. Related federal documents remain valid until they expire unless individually terminated. So the federal agency just laying out what the status is of DACA. And you have Illinois U.S. Senator Dick Durbin. He is on his way out. This is his final term. He's announced retirement, but he has reintroduced the DREAM Act. And if you've been following politics in Congress and Senator Durbin, you've heard about the DREAM Act for 24 years. It's a bipartisan bill that he's proposed for years, and it allows DACA recipients a pathway to legal status if they meet certain criteria. Among those criteria are no felonies, higher education, such, but also passing English language proficiency tests. According to Durbin's office, he says they are teachers, nurses, doctors, and small business owners throughout our communities and in all 50 states. But because DACA hangs by a thread in the courts and many are not covered by DACA, they live each day in fear of deportation. This is a matter of simple American fairness and justice. Durbin's office says across the country, there's about 530,000 individuals who are active DACA status. So, again, just in this overall conversation about immigration enforcement, safe roads, when it's on vehicles that federal officials rent, can they remove those or obscure those for safety purposes so they're not tracked and trying to enforce the law? You've got the ongoing court battles about the use of force and the National Guard and the state's migrant sanctuary policies, and then you've got the issue of CDL enforcement and whether or not people who know English are on the roadways with big rigs. So a lot of stuff going on here. Hopefully I've been able to distill it down so at least where the status of where everything's at and how we're moving forward here on this Friday with Illinois in Focus Daily. All right, each and every weekday morning with you. Greatly appreciate you guys' attention. Obviously, like, subscribe, hit that notification bell, and join us each and every day here with the Center Square. All right, we'll keep you guys informed. Don't forget to get the newsletter in your inbox. Go to thecentersquare.com. On the governor's desk is a bill that would allow for end-of-life options for terminally ill patients in Illinois, or as others may call it, physician-assisted suicide. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, and hit that notification bell. Wake up with us each and every weekday morning. Get the newsletter in your inbox. Just go to thecentersquare.com. Sign up today. So back on Halloween, early Halloween morning, the end-of-life options for terminally ill patients law was passed by the Senate, by the House, and now it's on the governor's desk. And Governor J.B. Pritzker saying that he hasn't decided yet on which way he's going to go, but clearly this is one of several laws that passed during veto session that's controversial. Other things we're still waiting on, that energy legislation that opponents say is going to add $8 billion to the rates of users across the state over a span of several years. And that means, again, rate increases coming your way. Supporters of the legislation say, hey, it does a lot to solidify the state's reliance in the future on renewable energy, and also has carve-outs for battery storage operations to get tax credits and such. So that bill's on the governor's desk. You have, a bill concerning the state's migrant sanctuary policies and enhancing those policies, but also, as our reporter Jim Talamonte points out in the weekend edition, which, by the way, I want to remind you can get the weekend edition of Illinois in Focus right here, and anywhere you get podcasts, just search Illinois in Focus, you'll be able to find that. But the migrant sanctuary enhancement bill goes further to hold people liable at hospitals, universities, and child daycare centers. So if they interact with federal law enforcement, somebody could bring a private right of action, a lawsuit against that organization. That bill's on the governor's desk. But also on the governor's desk, a bill that started out as a food sanitation bill, and it turned into a terminally ill patient end-of-life options bill, and the governor has this on his desk. But opponents of it are raising some serious concerns, including those who advocate for individuals with disabilities and also county coroners. So I want you to go to thecentersquare.com. If you obviously get the headlines in your inbox, you saw this, but here's the headline: Disability Group Coroners Press Governor Ahead of Assisted Suicide Decision. Here is the story from Katrina Barker, contributor for the Center Square. Chicago-based disability rights organization seeking a meeting with Governor J.B. Pritzker's office as Illinois prepares for possible action on legislation that would legalize physician-assisted suicide in the state. So again, Senate Bill 1950, which began as a bill about food sanitation, passed as the End-of-Life Options for Terminally Ill Patients Act in the early morning hours of Halloween. You have Linda Holmes, who sponsored that, saying, very simply, this allows a person age 18 or older who receives a diagnosis of 6 months or less to live and is mentally competent to make an informed decision to have the option of self-administering a prescription to end their suffering. Now, Senate Bill 1950 was sent to the governor on November 25th, and the governor was asked about the measure earlier this week at an unrelated event. Here's what he had to say.
I've been listening to everybody that has a view on it. I have not announced anything or decided anything. Every time I talk to somebody, it has a little bit of an effect. You're sort of cumulatively gathering information. And I know there are people who feel passionately on both sides. I have said before that I have friends who've gone through this with their relatives. And it's painful for the person who's experiencing the pain in the last 6 months of their lives, as well as for the entire family. And sometimes with the competent decision making on the part of somebody who's suffering, it feels like for them it was the right thing to do. I'm talking about a specific circumstance I can think of in another state. And then at the same time, I understand people who have religious values that say that this is inappropriate and that we should just provide hospice care and maybe make it as comfortable as we possibly can for somebody who's dying. So it's a hard issue, and I don't want anybody to think that making up your mind about this is very easy. It's not. I think there's a lot to consider, but most of all, it's about compassion. And again, there's evidence and information on both sides that leads me to think seriously about what direction to go.
And the governor
it's actually something that I brought up.
If he talked
we
with
didn't
the
have a
Pope
conversation about it because we were just, at the beginning of our conversation, I think he and I were both kind of dismissing to each other the things that we may disagree about, because there are very few, honestly, but kind of acknowledging that there may be things that we disagree about. Obviously, we are members of different religions that don't really disagree so much as just have differences in that way. So it was a kind of a brief part of a conversation in which we were dismissing all those things and then getting to the things that we really have so much in common. And I so much respect who he is and what he represents. And of course, the fact that he's from the state of Illinois is a great point of pride for all of us, I hope.
So again, the governor discussing a bit about some of the conversation he had with the Pope when he visited him. What was that, last week or the week before? But the end-of-life options bill on the governor's desk, he says that he's hearing both sides. He's trying to get as much information as he can, but he's wanting to come at this from a compassionate perspective. And a policy analyst with Access Living, a group that supports those with disabilities having access, Sebastian Knowles, he says that he's requested a formal meeting with the governor's office to discuss this legislation.
So at this point in time, we don't have a timeline on it. We would hope that it's sooner rather than later.
And the governor, having gotten this bill back in November on the 25th, that obviously means that he's got 60 days to act on it, which that would put it at about January 25th before he has a deadline to act on it. Now, in Illinois, the governor can sign the bill or he can veto the bill. But if there's no action taken on the bill by that 60-day deadline, it automatically becomes law. So could that be when this happens? But Knowles, again, with Access Living, says there are substantial problems they have with this particular piece of legislation when it comes to those who have disabilities.
You go and you look at individual states that have passed this. There is no mechanism that is dedicated to reporting abuse and coercion for accessing assisted suicide, for individuals who are accessing this.
So Knowles raising those concerns in hopes to have a meeting with the governor on this. But it's not just Access Living and others raising concerns. You got organizations like Right to Life that are collecting petitions to deliver to the governor ahead of the January 25th deadline for him to act. But you also have county coroners. Peoria County Coroner Jamie Harwood saying that coroners across the state have, quote, grave concerns about the bill.
Yeah, so, our statutory obligation is to determine the errant cause of death of all deaths within our jurisdiction of our particular counties. Once a physician prescribes that medication, the person goes home and takes that medication. The coroner's office is completely taken out of that picture.
And he says ultimately that obscures the real cause of death.
It takes the truth out of the cause of death.
And how this is going to ultimately end up with the governor having the bill on his desk saying he is going to focus on compassion in the decision he makes. We'll keep you posted. All right. It's Illinois in Focus Daily. By the way, we've got 297 laws that go into effect January 1st in some capacity. So between now and the end of the year and into the first part of the new year, we're going to do what we can to unpack some of those 297 bills that become law after the governor enacted them either over the summer or, veto session or any time from the past 12 months. So that's 297 laws that are going to impact you, businesses, education, the Second Amendment to the Safe Gun Storage Act, for instance. That part of it comes into effect January 1st. So lots of stuff for us to tackle here. That's why you need to like, subscribe, and hit that notification bell with Illinois in Focus Daily, only with the Center Square. I'm Greg Bishop, editor of Illinois at the Center Square. Get the headlines in your inbox at thecentersquare.com. All right, that's all I got for you guys this Friday. Greatly appreciate you joining. It's good to see the listeners and all you guys piping in and just chiming in on the live chat, so you can go check that out. Only when we're live, though. All right, somebody's asking SB 1950. Yeah, that's the end-of-life options bill. Somebody saying they called the governor's office about it. So yeah, a lot of buzz in there in the chat. So go join that in the mornings live. But obviously, if you can't make it live, you can comment below the restream of it. You can find segments of the program, get the podcast, Just search Illinois in Focus and you'll find it. And also, don't forget, you got the weekend edition. The Center Square's Jim Talamonte and I, we talk about a whole host of stories in a nice truncated weekend edition, Illinois in Focus. Broadcasts across the state on radio stations, so find your local listing. But you can also listen to it right here on YouTube. If you like, subscribe and hit that notification bell. Have a great weekend. We'll see you back here Monday. Happy holidays. I just say how incredible it is that there's still like 160 people watching right now. I guess you guys enjoy the music. Well, that's good to know. All right. Have a great Friday.